The big question then, is the Modi government simply now spoiling for a fight with the judiciary? Is judicial review of laws a must, or is it also resulting in judicial overreach? Is constitution paramount, or is parliament paramount in this country? The constitutional questions. Siddharth Luthra, former Additional Solicitor General, joining me. Another former Additional Solicitor General, Bishwajit Bhattacharya, with me. Ami Yagnik, Congress MP and lawyer, and Vivek Subba Reddy, BJP leader and lawyer, with us. I'll come to the politicians in a moment, but I just want to get the two legal eagles to give us their perspective. You first, Siddharth Luthra. Do you believe that we need to relook at the basic structure doctrine, that Parliament is sovereign, as Jagdeep Dhankar says, and therefore the basic structure doctrine needs to be reviewed, relooked at?
I think I would put it another way. Fundamental rights chapter is part of the basic structure, amongst others. Would you or I want the fundamental rights chapter to be diluted? The answer is obviously no. So let's understand one thing, and this is a matter of some concern. The Vice President, an erudite lawyer of his time, like all other constitutional authorities, took an oath to uphold the Constitution and the laws. The law declared by the Supreme Court in the Keshwananda Bharati case is the law of the land, which every authority has to uphold. The Constitution recognizes that there is separation of powers. The role of the courts is to ensure that executive and legislative power is reviewed. That's the power of judicial review, and kept in check. And part of the checks is that there should be no breach of the basic structure, as pronounced in the Keshwananda Bharati case. Having said that, we must not forget that the basic structure has helped us in times of crisis in ensuring that the Constitution is not revoked. Otherwise, I mean, if the basic structure didn't exist, you'd come along and, like some of our neighboring countries, the Constitution would be revoked on a regular basis. That is the whole purpose of this doctrine. I must also add that in our democracy, when we gave ourselves this Constitution, the Constitution provided separate roles for the legislature, for the executive, and for the judiciary. Those roles are cast under the Constitution. And today, to question that, to question the basic structure, is really questioning the basis on which this republic was founded. A lot of thought went into giving ourselves this Constitution, and it is unfortunate that this is now being questioned by no less than authority than the Vice President himself, as I said, a competent lawyer.
You're saying that the Constitution envisaged a clear separation of powers, but Bishwajit Bhattacharya, the argument that the political class is making, and we'll come to them in a moment, is that there are times when the judiciary appears to be taking over tasks that should be left to the legislature. So Parliament is sovereign, is what Jagdeep Dhankar is saying, and therefore believes that we must review the basic structure doctrine, because it expands the power of the judiciary, can lead to judicial overreach, and judicial oversight is leading to overreach in the case of Parliament.
Rajdeep, the fundamental concept of these two highest constitutional authorities which they have uttered is deeply flawed. Perhaps they didn't have the time to go through Article 245 of the Constitution of India.
Let's be specific. Why do you believe that Jagdeep Dhankar is out of line?
Because it flies on the face of Article 245. Parliament's lawmaking power is circumscribed by the provisions of the Constitution. The interpretation of the Constitution is the job of the judiciary. And in the NJP case, the government has lost once, twice when the review petition was dismissed, and now from 2015 to rake up the issue while holding high constitutional posts, and not before that. and in unison by the two highest authorities within the top five. I think this is total reckless disregard of Article 144 of the Constitution,
No, but there are
reckless
those...
disregard of Article 141 of the Constitution, and basically it is the job of the judiciary to interpret the Constitution. Even a first-year law student will know.
But if,
so this kind of a poor
but how does the appointment of, you see, I think where this has come from is that entire NJC judgment of 2015 of the National Judicial Appointments Commission judgment, which the judiciary refused to accept, saying it would be a violation of basic structure. You've got the likes of Mr. Dhankar saying that how can judicial appointments be part of the basic structure? Why should judges have primacy?
No, you see, the basic structure is a proposition laid down by a 13-judge bench of the Constitution from 24th of April 1973 till today. Half a century we are going to complete on 24th of April. So that's the law of the land. Now, if you have to challenge that, you have to set up a 15-judge bench. And for the high constitutional authority to talk in this manner is very, very unfortunate. And I think this is tarnishing the image of India. That the highest constitutional authorities are openly attacking the majesty and sanctity of the Supreme Court. They have not gone through Article 245, Article 141, Article 144.
Let me bring in Mr. Reddy. I'll come back to you, Bishwajit, in a moment. Mr. Reddy, No, it is time to call a spade a spade. Now, don't be afraid. You are one of the few channels. So therefore, don't be afraid. Hear me. The question is that when constitutional authorities, after occupying highest constitutional post, they themselves attack the Constitution, whose creature they are, to say that Parliament is sovereign. I'm sorry, Parliament is not sovereign. Nobody is sovereign. Constitution is sovereign. Okay, that's the line of the day. The Constitution is sovereign, Parliament is not sovereign. I'll come to you, Siddharth, in a moment. Just a minute, sir.
Bishwajit Bhattacharya, power of the judiciary to interpret.
You made very strong comments. I think it's only fair.
Parliament cannot interpret the Constitution.
Okay, let Mr. Reddy respond. Mr. Reddy, Constitution is supreme, not the Parliament. If the Parliament commits excesses, as happened during the Indira years leading to emergency, it is the job of the judiciary to act. The Keshwanand Bharti case has stood for 5 decades now. Why this sudden need to review it?
No, you can review it, but set up a larger bench.
Okay, let Mr. Reddy respond.
Well, Rajdeep, what the Vice President has said has set off a debate on the Keshavananda Bharati judgment. I think debates are welcome, even if it is from high constitutional authorities. They have a right to speak. They have a right to say what the law should be, how the Constitution should be interpreted. After all, the two senior counsels who are on record here, the basic structure doctrine was never prescribed in any part of the Constitution. The Constitution never said that this is the basic part of the Constitution, this is the non-basic part of the Constitution. There was no basic structure theory at all in the Constitution. But the judges divined it, they interpreted it. I am not saying that they are wrong. They have
what has suddenly changed? Mr. Reddy, what has suddenly changed?
It has its sanctity.
What has suddenly changed? What has suddenly changed for calling for a review of the basic structure judgment?
We need to understand the Vice President's perspective. The Vice President was talking about the NJC Act. The Vice President was talking about the NJC Act. The NJC Act in 2015 was scrapped, was quashed by the Supreme Court, holding it unconstitutional on the ground that it vitiates one basic principle of the Constitution, which is independence of the judiciary. That's the core controversy. So the Vice President was asking that if Parliament cannot make a legislation on appointment of judges, the system of judges appointing themselves, is this right? Is this constitutional? Well, I think he has a point there. Judges appointing judges, and we have seen that the collegium system is not foolproof, though it is good, but it is not foolproof. It is not sacrosanct to say that it has it has crossed all hurdles or all deficiencies.
Okay, so you're
Today we find that judges are also looking at or eyeing certain relatives of judges who have been appointed. So this sort of a subtle favoritism, if at all it is there, I think that is also serious. And we have a right to question this. Okay. That is not constitutional.
Okay,
that is not a part of the constitution. In fact, it violates the basic feature.
Let Ami respond. Therefore, I would request
he is right in raising these issues.
You believe it's important to trigger off a debate. Ami Yagnik, your response, because the Congress party is already suggesting that this is part of some larger conspiracy to undermine the judiciary and judicial independence.
See, first of all, Rajdeep, this statement which has come from the Honorable Vice President of India, I think it is unprecedented. And in fact, as a law student and a practitioner of law, and having immense faith in the judiciary and a law that has been 50 years down the years, you know, with 1973 Keshwanand Bharti, that the basic structure of the constitution cannot be altered. I think it was very constitutional, this statement coming from the highest constitutional authority, the Honorable Vice President of India. This is a statement which is, I think, it is attacking the constitution, because the constitution is supreme. Parliament makes laws, the judiciary interprets it, and if it contravenes the basic structure of the constitution, it is slashed down. It is practically given a go-by. So what is wrong in that if the judiciary protects the constitution?
Vivek Reddy is saying that there is a particular context of judges appointing their own.
The question of saying that Parliament is supreme.
Vivek Reddy is saying that in the context of the manner in which judges are appointed, should Parliament be supreme or should judges? Are we saying that this is frozen in time? Nothing is frozen in time. You can review aspects of the constitution.
No, Rajdeep, I think, Rajdeep, there is a system in place, and for so many years and decades, there has been this system, and the government is also a party in this when the recommendations come. But if there are certain deficiencies, you can try to figure them out and solve them. But just to say that Parliament is supreme...
But where are the checks and balances?
Everyone is surprised.
Like in any other administrative decision.
The Constitution is supreme.
Oh, both of all the panelists who are questioning what
Rajdeep, where are the checks and balances? The judiciary appoints itself.
Okay, Siddharth Luthra, you want to respond?
Judiciary appoints its own judges. Where are the checks and balances?
Siddharth Luthra, Mr. Reddy is saying, where are the checks and balances? If judges appoint their own, does the legislature have a say or not? That's what the Vice President was effectively alluding to.
I think first the golden words which slipped out from Mr. Reddy, that the collegium system is good, we need to cast that in stone. The second most important thing is, you lost the NJAC decision. What stopped you from bringing an amendment which would have dealt with the concerns the Supreme Court had stated in the NJAC decision? If you believe in the Constitution, if you believe in democracy, please bring an amendment to the Constitution. You are entitled to do it. You're the party in power, and you can place it before Parliament. Get it passed through Parliament. If necessary, it will be tested in court. If it is good, it may not even be tested. But is this the way that our debate is going to go on, where we decide to we have these conversations, these pronouncements in public fora? There is a mechanism to amend the Constitution. If you choose not to do it, then the question is, do you believe in the Constitution as you are bound to do? And that is the question that needs to be asked today. It's a matter of serious concern. Number 3, let's be very clear. In India, the Constitution is supreme. We are not like the United Kingdom where Parliament is supreme. We have a written Constitution that divides the powers. Yes, there has been a graying of areas, but merely because you lost the NJAC judgment, it's not a case of Angur Khatte The.
No, where are the checks? Siddharth Luthra,
if you believe in it.
Luthra, where are the checks and balances? The point Mr. Reddy is making, where are the checks and balances? If there is judicial overreach, who
So I'll tell you the checks and balances.
Checks and balances.
I'll tell you the checks and balances are very clear. Every time a recommendation goes of an appointment of a judge, it goes to the government vets it, there are security clearances done, and the government comes back with its observations. and his comments to the Supreme Court or the Collegium in the High Court then looks at those objections, sees those concerns, and either reiterates the name or drops the name. Please let them come out with numbers where legitimate concerns have been raised by the government and the Supreme Court Collegium or the High Court Collegium has declined to accept them. Let's talk numbers and statistics. Let's not talk in the air on perception.
No, that is the situation.
That
is the situation.
1 minute, Mr. Reddy. The fact is, this government in the last year or last few years has been sitting on various recommendations made by the Supreme Court Collegium, sending them back, at times refusing to accept it. You had a 2-year hiatus as a result where no appointments were made. So clearly this, and you've got the law minister of the country, Vivek Reddy, who's openly saying we want to discard this system, who's openly in a way challenging the judiciary. Is this the way to conduct a debate is the question. If the Modi government's spoiling for a fight, that the Modi government seems to want to have a fight with the judiciary.
Rajdeep, it is not confrontationist, neither is it an attempt to create a rift or a rupture between constitutional bodies, but the issue is that there has to be a healthy debate. The government is pointing out, the Law Minister and Jagdeep Dhankar, the Honorable Vice President, both of them are pointing out certain serious concerns in this whole system.
Take it to Parliament, sir.
Now, if there are certain recommendations, as one of our panelists said, if there are certain recommendations which are not worth it or which cannot pass the muster, and it is still reiterated by the Supreme Court, then what must the government do? Where is the check and balance? So these are the concerns.
You've said that for the second. You've said that for the second time.
I disagree with Mr. Luthra when he says that you can't have a public debate. You can't have a, what do you mean?
Let's talk about instances.
Institution.
Let them give those numbers
one by one, please.
Not something, a statement to be thrown off the cuff of your head.
Mr. Luthra, just a minute. Bishwajit Bhattacharya, you want to take that? Again and again, Vivek Reddy is saying checks and balances are needed. The judiciary cannot arrogate for itself the right to choose its judges. If the government believes that there are some elements of, that the system isn't working, they have every right to voice their concerns.
Rajdeep, the basic question here is checks and balances exist already in the system. There is a process, as Mr. Luthra has pointed out, various channels are there to keep checks and balances. There is an impeachment procedure also for an errant judge. But today is 12th January. Recall what happens 5 years back. Today, on Swami Vivekananda's birthday.
Vivek Reddy, 1 minute, let him complete.
4 judges, Rajdeep, 4 judges today, 5 years back, revolted. Why did they revolt? Why did they revolt? There was an attempt to control the judiciary. So this is a turf war, and judiciary cannot afford to lose this. So this is an orchestrated turf war going on, because today Article 144 says all authorities, judicial and civil,
this is a way to cover up the deficiencies in the system.
Article 141. The government is
pointing out the deficiencies.
Article 141.
Okay, Bishwajit, you've had your word. Bishwajit, you've made that point.
It is not an attempt to cobble the judiciary. I am sorry.
No,
it is not an attempt to cobble the judiciary or to take a grip over the judiciary. It is a healthy discussion, a debate on the deficiencies in the system.
India's international image is going down.
Okay, you know what? The fact that the
I am sorry, Mr. Bhattacharya. I am sorry.
That is not the tenor. Vivek Reddy, is it not?
No, 1 minute. Argument.
Vivek Reddy, is it? Vivek Reddy, does it behove the law minister of the country no less and the vice president no less to openly take on the judiciary in this manner in public? Do you believe, will this not be seen as an attempt to undermine the independence of the judiciary? Is this the manner in which, it's the manner in which, no one says there shouldn't be a debate. But if you are going to conduct this debate in a confrontational manner, what's the message that's going out? That you expect the judiciary to toe the line of the government?
Well, see, Rajdeep, so far as the issues raised by Jagdeep Dhankar, the Honorable Vice President, on the doctrine that has been existing since 50 years, there's nothing wrong in having a healthy review about it, or a discussion about it, or a debate about it. And the law minister also has pointed out certain deficiencies. Perhaps he has seen certain things which he feels must be orchestrated in the light of the judiciary having the sole power. Now the sole repository of the power is judiciary. You don't want political interference, I agree.
No,
political
why don't
interference
you,
in judicial
why is this debate, why does this debate not take place in Parliament? You know, is the opposition open to a debate on this in Parliament, Ami Yagnik? Should this debate not take place inside Parliament, a reasoned, rational debate? That's where the debate should take place, Ami Yagnik.
No individual, president or vice president or prime minister, can alter a 13-judge bench. There is a rule of law. There is a procedure in the country.
No, they are not altering it.
Just by attacking the judges.
They are suggesting, suggesting a healthy discussion.
Can I ask Ami Yagnik?
What is wrong in a healthy discussion?
Ami Yagnik, is the opposition ready for a healthy discussion on this? Yes or no?
Yes, of course, Radip, we have been always asking for a healthy debate. Parliament is meant for discussion, debate and deliberations. And that is how we get a wholesome law, which is not subject to being attacked or being taken to the Supreme Court. And we are always ready for healthy discussions.
Okay.
But you have seen what has happened. The bills are bulldozed and hardly there is any hearing on the bills and a detailed deliberation takes place. So we are ready for, always we are ready for a healthy discussion on any bill that is brought in the Parliament.
Okay, so effectively the real question is, and I think we accept that the Constitution is supreme, and really we need to go back in a way to the Constitution and look at the manner in which the Constitution can be protected from any attempt at overreach by any institution. We have a fine Constitution. It's the manner at times which it is interpreted and used which is under question. I appreciate...
And interpreted by the court.
You're saying interpreted by the court, point well taken.
Not the Parliament.
Your point is well taken, Mr. Bhattacharya, but I've run out of time.